Good afternoon, everyone, and thank you so much for joining us to this amazing webinar. The webinar is about a pending case that is currently being heard in front of the Grand Chamber at the European Court of Human Rights in the names of Kurt versus Austria. The case concerns the murder of a son of a boy, and the applicant took the case to the European Court of Human Rights, arguing that the state failed to protect and provide effective protection because the father was an abuser and there was history of domestic abuse. The application was represented by the amazing Sonia Aziz, who will be joining us, and she'll be telling us much more about the case that submitted an application to the European Court of Human Rights, complaining that, as I said, the Austrian authorities failed to protect. Arguing as well, the application was also based on Article 2, which is the right to life, and Article 3, prohibition of inhuman and degrading treatment, and Article 8, which is the right to respect for family life. We have four amazing panelists with us, Dr. Aziz as well, Rosa Logar, Elena Biaggioni, and Maria Adriana Costopoulou. And I will be today facilitating this webinar. The other three speakers have also taken part in this amazing case, whereby they had presented third-party interventions. Just a couple of logistics for the webinar, because we really do have a very tight time and we definitely want to give enough space for our speakers to present, to have the presentations, and time for our participants in order to provide questions. I would really ask the panelists to keep and stick to your allocated times. We will be flagging you just in case you will go over. And then if anybody will have any questions, to please put them into your Q&A. Okay, you can put your questions in the Q&A or in the chat box, or raise your hands. The webinar is being recorded, and the webinar will also be made available on the WAVE website once it is published. And just for time constraints, I will start off with our first panelist, Dr. Sonia Aziz. She is a lawyer based in Vienna, Austria, representing Ms. Kurt in front of the National Court of the European of Human Rights. Dr. Aziz will shortly present the case, and she'll tell us a little bit more about the legal arguments that have been used. The floor is on to you, Sonia.
Thank you, Lara, for this very nice introduction and your words. I'm happy to be here and that I was invited today. Let me just correct, I'm not a doctor, I'm just a magister, but yeah, I'm the representative of Ms. Kurt. Mrs. Kurt is the applicant of this case we are talking about. It's an Austrian case which is in front of the Grand Chamber, and the hearing was last week, so everything is very current. Let me give you some facts of the case so that we all know what we are talking about. My client is the mother of Berg Kurt, who was shot by his father in 2012 in Austria, in his school, in front of his sister Beren, who was 1 year younger than her brother. This fatal incident was preceded by a long-standing history of domestic violence, as we heard. The father had been violent towards his wife, my client, since they got married in 2003, and especially when he struggled with financial problems, which happened regularly due to his gambling addiction. He had repeatedly used violence against the applicant, but also against the two children. In 2010, he had already been convicted because of bodily harm. He was violent against his wife, and he also threatened his nephew and his brother. Therefore, there was a court case in 2010, and he was sentenced to 3 months imprisonment, which was suspended for 3 years with probation. So as we can see, what he did to his son happened within this probation time, because it was only 2 years after his last sentence. He then voluntarily went to a psychiatric hospital and underwent treatment for his gambling addiction. He asked his wife for forgiveness, and she gave him another chance. But then by February 2012, so 2 years later, the situation had drastically worsened again, and he had taken up gambling again, and he was being very violent towards his family, also to the children. They later reported this to the police, actually 2 days before the son was shot. And the police did not do what they should have done, but we will come to this point later on. What he regularly said on a daily basis was he was threatening his wife with killing the children in front of her eyes, or killing the children in general in case she leaves him. That was always the threatening. So we come now to May 2012. There was an escalation of violence against here. It was a Saturday, 19th of May, and he raped her, and he was very violent. It was Saturday. She did not have any contact to her counselor, her psychosocial counselor from the Gewaltschutzzentrum, the protection center in Austria. They already had a very good relationship because since 2010, since the last incident, which was also in front of the court, they had a very good relationship. And on Monday, she called her and said, I have to flee out of this partnership. I'm so afraid that he could really kill me and the children. And what they did is the next day, on Tuesday, my client, supported by her psychosocial counsel, they took the first chance available and they filed for divorce at the district court in her city. And these district courts offer the possibility only on Tuesdays that people can show up and ask for petitions for divorce, and they can record it without a lawyer. So that's what they did on Tuesday. And she gave several reasons why she wants to divorce her husband. And she also stated that beginning of their marriage, he had begun to beat her and also the children, and that she is very afraid because of the threatenings. And that's why she then, after this divorce file, she decided to immediately go to the police. And she reported her husband to the police for the offense of cruelty towards her and also her children, the dangerous threats, the rape, everything that happened in the past years. And she also said that she is especially concerned that he's going to kill the children now, as she has filed for divorce. But the police did only issue a bearing order. A bearing order concerning the home and the home of her parents, because she said she will stay there for a few days now. The school of the children was not informed by the authorities. Also, a bearing order covering the school of the children could not be issued based on the law in force at that time. That was also the reason after this incident that the law changed because of a big protest of the protection centers in Austria. The law was changed, and since 2013, bearing orders could also protect the school of the children who are endangered. A very interesting fact is that in 2019, this law was changed again, and since now, there are no bearing orders covering protection at the school anymore. They changed that law. But we will talk about this maybe later. She also told the police factors for a heightened dangerousness of her husband. She told them about the previous reports, the violence, the reported and the unreported acts of violence, the escalation concerning frequency and intensity of violence, also the current stress factors like his unemployment, the divorce, his separation of the children, that he does not accept her divorce wish. But the police did not do everything they could. So what we argued in this case was mainly that the authorities could or should have known at the time that the applicant's husband posed a real and immediate risk to the boy's life, which required more serious measures to be taken, such as taking the perpetrator to pretrial detention. And also, we argued that neither the Austrian Public Prosecutor's Office nor the Austrian police had a specific risk assessment tool, in particular to assess lethal risk as required by the Article 51 of the Istanbul Convention. And they still don't have any. Still now in 2020, they don't have any tool. And third, we also argued that there was a lack of knowledge regarding the dynamics of violence, which led to wrong assumptions. In Austria, you have to know, public prosecutors, judges, they have a very, very, very long education to finally be a judge or a public prosecutor. It is about 4 years after finishing studies, but they not really know anything about domestic violence and also the dynamics. So that very often leads to wrong assumptions, and that was also the case in Kurt versus Austria. Let me begin to point out that at the relevant time, we argue that the authorities had all information they needed to identify the lethal risk of the applicant's children. The government said they did not have any information, but the Mrs. Kurt went to the police, she told everything, and then her children were questioned, and both were telling the police that also they are beaten up regularly, and the mom also is beaten up by the father, and that they are all afraid. I also, in this hearing, quoted the kids when they were talking to the police. And let me find this, maybe I find it. But let me first say, the government claimed in their observation that before the murder of my client's son, the Austrian authorities and courts had no information or indications from which they could have concluded that there was a real and immediate threat to the life of her son. And this claim is misleading because 3 days before the murder of her son, she had reported her husband to the police, and she referred to several risk factors, and she expressly mentioned the protection of her children from her husband as a motive for filing the police report. Therefore, at the relevant time, the authorities had all information they needed to identify the risks. They had the matching statements of her children and herself, and they also had injuries. They made photos of her injuries, which she had on that day. And so they had a lot. And also, the perpetrator was questioned by the police, and he was contradicting himself all the time. And it was not matching with the other statements of the 3 victims. So to say they did not know everything is just misleading and not true. However, the bearing order only covered the family's home and the home of her parents. And there was still a big risk for the children at home. The government always argued that in the beginning or during the relationship, he was only violent at home. So how should the police know that he would be violent outside in public, like in the school? But of course, because of the bearing order, he could not go home anymore. And where should he look for his children if not at school? He knows that they are there every morning, and that's what he did. In the morning, he went there and he asked out his children out of the classes. He wanted to give them money or anything for lunch. And the teachers were not informed by the police, so they let their children outside. And then he shot his son in front of his daughter, who fled. And afterwards, the perpetrator killed himself. And to say, like the government and also the European Court of Human Rights in the Chamber decision did, they said, the applicant herself seemed not to have been aware of the acute danger emanating from her husband in respect of their children. And this is not only contrary to the facts, but tries to also shift the responsibility principally placed on the state onto the applicant. And this is not correct. It's the police who have to protect the life of her son and not the applicant doing something wrong. The government said she should have asked for a restraining order to prolong the bearing order and to also have a protection at schools, because restraining orders can also cover the school. But this is a civil measure. It's not a criminal measure. And it's up to the client, to a private person to do that. It cannot, it does not mean that the police then does not have to do anything anymore. So they have to protect. And that's what we try to explain. Also, what we try to explain is because of yes, they did not have a tool. That is correct. There is no tool until today where they can have a look if somebody is endangered or not. That despite of a lot of also the third party interveners said there should be a tool, but there is not in Austria. Also, Grevio pointed out that this is missing in Austria. And we can still see that there is no risk assessment tool in Austria. In summary, in assessing if a person's life is at risk and a perpetrator should be taken into pre-trial detention, neither a standardized risk assessment tool designed for domestic violence nor any enumeration of specific risk factors is or was used. But it is essential to point out that the more important than the type of the chosen tool is the need to use it systematically, and that the authorities have a profound knowledge about domestic violence. And that is what we also pointed out, because in 2019, the Austrian government initiated a task force, criminal law, to improve the protection of victims. And 120 experts were invited to make recommendations. I was one of them, and I have the report of this task force. And the task force report of the Austrian government says that there is still, in 2019, a lack of understanding of domestic violence due to a lack of awareness in the professional training of prosecutors and judges, as I explained before. And they also stated that the seminars on the topic of violence is not sufficient to provide a comprehensive understanding of the diverse and complex issues involved. So in the present case, the lack of knowledge regarding the dynamics of violence led to a serious misjudgment. For example, the Austrian authorities failed to identify the children as endangered persons. Up until now, the Austrian government says the children were not endangered. How should we have known? It was, of course, the wife. She said that she's being beaten up and experience violence, but the children, we did not know that. And that's completely not correct, because as the third party interveners also showed, violent men know that children are most important for their partners, and that they also kill joint children in order to hurt their partners. This is also why the applicant's husband threatened to kill the children. And the killing of a child is always an act of aggression against a woman too. This is why any risk assessment must address systematically the risk not only for the woman concerned, but also for her children. And the authorities involved must fulfill their obligation to protect the children on the slightest suspicion that they might be at risk. And here it was very clear. The children told the police they are afraid of their father. He is beating them up. And Also, he knows the victim's daily routine. So although domestic violence often takes place at home, because this is the arena of control and access, the access and not the location is the defining feature of where the violence occurs. And since the perpetrator was banned from home, of course, he went to school. He had access to the school, so the risk was evident. But there was also another misjudgment because of the lack of knowledge regarding the dynamics of violence. The Austrian authorities, for example, underestimated the dangerous threats as an indication of real danger. They said, he has always threatened to kill the children and he never did it, so how should we know that now it's a real danger? And I'm so thankful that the third-party interveners also had something to say to this part. They said that it is shown that according to their expertise, this is incorrectly interpreted as a sign that the threats will not be carried out, but in fact, most of the homicides are committed preceded by threats. So this is very common. And also the authorities expected that my client has to be the perfect victim who reports the crime immediately after the first insult, who always contacts the police whenever her husband shows his violent behavior, who documents all incidents and requests a temporary restraining order on the same day as the bearing order. And this approach disregards the dynamics of domestic violence too, and the imbalance of power between men and women, often given in these cases of domestic violence. And it also affects the victim's behavior, so towards the outside world. So this was also a lack of knowledge by the authorities. Furthermore, our client in this case, she did take actions. She went on the first working day after the rape to the divorce lawyer, divorce judge, and filed for divorce. And she filed for a police report. She did a lot, but nevertheless, nothing happened. Only a bearing order was issued. And one thing which and then I'm gonna come to the end, what the Austrian authority also always said in this case was, he presented himself very calm and polite and cooperative towards the police. So according to this, how should have known that he's a violent and dangerous guy? And the third party's interventions also said that this is a grave error. A closer analysis with the perpetrators show that they often appear to be very adapted and controlled to the outside world, and that they can accept subordination to the authorities like the police. But this does not, and on no account, mean that they are not dangerous. In the microcosm of the family, they maintain their power over their partners with violence. So this does not mean anything. And also the assessment of the level of risk or danger cannot depend on whether the perpetrator presents themselves as aggressive or cooperative and calm to the officers. Otherwise, the arrest or placing under pretrial detention would always be dependent on how well an accused person manages to sell himself. So this cannot count, and the fact that her husband contradicted himself again and again in his statements should also have shown the authorities that he's not trustworthy, but more my client and her children. Yes, maybe there is a lot to discuss afterwards. I think that my time limit is already extended, and thank you for listening.
Thank you so much, Sonia. I think if you had to look at the spectrum of violence here, we hit everything, including children being bystanders and direct victims of violence. Perhaps also of concern is the fact that even at the first chamber of the European Court of Human Rights, the court itself at that point in time failed to acknowledge the threats and the risks and the victim blaming as well as shifting the responsibility of the state onto that of the victim herself. I will now move on to our second speaker, Rosa Logar. She is manager of Vienna Intervention Center and member of the WAVE board. When Rosa worked on the third-party intervention that WAVE submitted to the European Court of Human Rights on behalf of Ms. Kurt. In her presentation, she will focus on the main arguments regarding the due diligence obligation of the state to proactively protect victims from violence and harm in relation to Kurt versus Austria. Rosa, the floor is yours. Rosa, your speaker is, you need to put on speaker.
Oh, sorry. So thank you for giving me the floor. Yeah, as Lara said, I will focus on the question, the reasons to write the third-party statement in this case on behalf of WAVE and arguments in it. But I also want to mention that it's a pleasure for me also to be in this group with some of my former colleagues from Grevio, current. We were not really overlapping much, but still. And I've also seen on the list that there's some more listening. So I have been also a member of the committee drafting the Istanbul Convention and served 4 years on the Grevio committee. The reason why I suggested to the WAVE board to apply for a third-party statement was, of course, that it's an Austrian case and that I know a lot about it. And actually, I also wanted to thank Sonia, not only for taking on this case, but you have to know that in our center, we serve about 6,000 survivors of violence against women and domestic violence a year. She's our main and favorite and best lawyer. She is representing many of our survivors in court, more or less on a daily basis, and we wouldn't know how to survive without her. I think you should also know that she's not only working with cases in the European court, but a lot here in Austria. She's probably the most experienced victims' rights lawyer in our country, I would say. So yeah, why did I from the center support this statement? There's a history to that, of course, that you know, but I think it's also important to mention our center did bring 2 cases to the CEDAW committee, in which were 2 women who were killed by their husbands, and there are 2 CEDAW decisions, communications from 2005. It was Yildirim versus Austria and Gökçe versus Austria, actually very similar in the problems, and so these 2 cases and then had where Austria was found guilty to have not properly protected the lives of these 2 women because they regarded the perpetrator's right, his right to freedom, so to speak, more important than the right of the victim to be protected. So that's the reason why they didn't take the perpetrators in pre-trial detention, very similar to what we have with the little boy Berg. So these were very important cases for us, but as you can see, they didn't really have much impact on the Austrian situation because the problem sort of stayed. That's why we decided that we have to continue to raise awareness about this issue, because the problem is not solved, and there are more children, more women killed that who could be saved because the problem or the threats were known to the authorities, and so this is why we supported the case, and also suggested to WAVE to bring in this communication or this application. We wanted to raise awareness on the European level, because we also knew that it's not only a problem in Austria, it's a problem in all our countries. It's maybe a global problem, it's a universal problem. It has to do with the fact that the authorities and institutions are still biased. They don't understand, or they don't want to understand the risk. As Sonia has pointed out, it's not ignorance. It's also connected to the fact that violence against women and children is still a kind of it belongs to our structure. It belongs to the subordination of women and girls in our society. It's a means to keep women where they are. So it's very deeply in our structures. And so somehow, I mean, this is a very maybe radical analysis. Somehow our system are taking this death and killing of women, just accepting it as the price, so to speak, for male dominance. It's a very harsh criticism, I know, but I think we have to be very clear about that. If we don't address that, we will not solve the problem. It's not only a problem of not knowing or not having enough training. So that's why I fully supported to bring this case to the European Court, and also to have a third-party statement of WAVE, which is focusing on the risk factors, stereotyping and victim blaming, which Elena will talk about, and also the question of the adequacy of the legal framework. It's based, the WAVE statement is based on this due diligence obligation that the authorities have to proactively protect victims from further violence or from violence, especially if they know or ought to have known of any risk factors. So that was the jurisprudence of the European Court so far, and also of CEDAW. But this is also now in danger somehow, this definition of due diligence. That's why this case is so important. And as I said, the authorities often overlook or refuse to regard risk factors because they see violence against women as not as a crime, but as a normal thing or as a domestic quarrel. And even if the risk factors are very easy to identify, as Sonia said, they are so obvious, they are in the files of the authorities, and even then they say, we didn't know. I mean, it's kind of paradox, no? You can read it in the files, the risk factors, and they say, we didn't know this. It's as if there is no common sense, because every person would know if someone repeatedly injures someone and threatens to kill, that might be a risk factor. You don't have to have a lot of training to understand that. So the question is, why is this ignorance there? And that's what we tried to put in the WAVE statement also. We listed the risk factors that are very well known by now in theory and in practice. And we also pointed out what risk factors there were very clearly, openly in the files in the case. And Sonia has pointed them out. I will not repeat that because we don't have to take too much time for that. So that's what we were trying to say. But you did know, or you could have known, because it was all there. And so this, and also this question, I mean, sometimes this question is this, it wasn't a constant, the question of a constant risk, so to speak, as if the risk would stop between the violence acts. That's how the authorities sometimes see it. You know, there's a violence, and in between there is nothing, and then there's a violence again. So, but they have to understand that's a constant risk of immediate danger in such a situation, and you never know when it happens again. Can be in the next hour, can be in 3 days, and the fact that you can't know that, they take as saying, well, there was no danger in this situation. So I think this is something that the authorities also have to understand, that this constant risk and immediate danger of harm that is there all the time poses this obligation to proactively protect. Sonia has pointed out these stereotypical arguments, and you will hear more about that also from Elena, I think. I only focus on one more point, that I call the privatization of the obligation to of the victim to protect herself. So it's like as if the state is saying, well, why did she not do this, or this, did she not do that? That's of course victim blaming, yeah. But it's also that the state tries to shift the obligation to protect to the victim. Why did the victim not go immediately there? Why did she not do that earlier? Why did she do that? And it's a shift of responsibility, and we have to shift it back. And it's hard work to shift it back, because again, that's something so deeply in our structure. It's this responsibility of the woman, everything that happens in the family, and so it's the responsibility of women anyway. It's also their responsibility to protect themselves. And the Austrian authorities were doing that in many ways, also to argue, well, she didn't apply for the civil order immediately, and all this what Sonia said. And I think we also have to reject that. We have to say it's the state obligation. If the victim wants to protect herself as well, good. And every victim service or women's support services will do that. But that doesn't mean that the state is kind of free from this obligation. And you can't count on the victim to do that, because of many reasons that we know. The victims, we are traumatized as victims, we are afraid, and all these kind of reasons. So the strong pushing the obligation to the victim is one very strong element that Sonia had to fight against in the hearing. I hope she will have some time to tell us. I don't even know if you are allowed to talk about the hearing, but she had to push back, this obligation of the state, give it back to the state authorities. Okay, my final words. Berg could have been saved. I'm really, really convinced he could have been saved. And his mother and sister and family could have been spared this horrible, horrible fate. And that's why we have to go on fighting, so that these women and children don't die in vain, that they, at least we will do everything we can to make the world safer. And we are in a dangerous situation, because the backlash in Europe, the backlash for human rights, the backlash for children's rights, for women's rights, has also hit the European Court, I think. Because the fact that the case was lost in the first instance shows that that they are going back, or at least in this judge was going back in the standards of protecting victims. And so I think it's very important that we come together and continue our fight for human rights and women's rights and children's rights. Thank you.
Thank you, Rosa, for your passionate closure. I feel totally the same as well. And I think, yeah, it's very important. And I thank you away for intervening in this case in particular, and, highlighting the importance of due diligence and the importance of positive state obligation and holding them to accountability. And yes, it is a bit of a concern to see that at a level, at a European human rights level, that we tend to see that there seems to be some form of regression, but hopefully with Sonia's very passionate also intervention and her grand chamber, we have managed as well as the intervention. So we'll wait and see for that. Okay, I'll move on to our next speaker, Elena Biagioni, lawyer from Dire, Italy. Dire, Italy also submitted an intervention in this particular case. Elena will talk about the importance of taking women's voices to high courts and about the legal arguments used in third-party intervention submitted by Dire in the Kurt case. Elena, floor is yours.
Thank you very much. Thank you very much, Lara. Thank you very much, Rosa, Sonia, for your passionate intervention and discussion in front of the European Court. I listened to it with great satisfaction. It was really good, so many good legal arguments that we need to share and to disseminate, because it is very important to have this peculiar perspective. It is not only a matter of knowing domestic violence, but implementing domestic violence, the knowledge we have of domestic violence and domestic violence patterns into legal standards. This is the core intervention we need to push. And this is also the reason, because we're here today, and it is also the reason we had a third-party intervention. When we heard about the case and we discussed the possibility to write an intervention as dire, which is a network of more than 80 anti-violence center and women's shelters in Italy, we immediately realized that very few women have the chance to go up to the higher courts. And this is very important. We need to have our voices heard at high courts. In Italy, for example, we rarely reach the high courts as women lawyers. Why? For the same reason you explained in front of the court. Because access to justice is very hard for domestic violence survivors. It is exhausting. Our clients, after the first level in courts, are exhausted. It is so difficult, it is so hard, it's so costly. The push and the attention and the burden is everything on the woman, on the victim. For the same reason we explained about victim blaming, is just putting all the difficult part of a trial is in the woman's shoulder. And that's why they don't go further. They wouldn't appeal decisions. So they don't, we with them, don't exhaust internal remedies. And so who makes a higher jurisprudence? Men, perpetrator, asking for better conditions. And we should stop this. So I'm not saying that we all need to go to the higher courts, but once one of us reaches those courts, we need to stand together and to fight together and to offer our knowledge, expertise, and also the ability we have to look into the cases from different perspectives, from our experience. We know what happens. We know, because it is the same everywhere. The same reasoning, the same legal restraints that we have are the same all over Europe. And we realized that. When I was listening to your discussion, I was thinking it's just the same that we have in Italy. They would use the same arguments in Italy. So we need to strategize more, to disseminate the content of your arguments, which are the same one we use everywhere. And that's why most of the third-party intervention could overlap, because most of them, or most of us, faced the same core arguments. And what was it? The lack of training, the lack of understanding of dynamics of domestic violence, the underestimations of risk, the lack of risk assessment, victim blaming, judicial stereotyping. It is the same happening all over. And I think we have great video members here, and they also find patterns of these all over Europe when they write their report. Since the problem is the same, we need to share the knowledge we have on how to stop it or to fight it back, at least. And yes, Rosa, I think backlash can reach the European Court of Human Rights. But as lawyers, we know jurisprudence can change. And that's what we have to do. Keep on working on that, submitting better arguments, starting from the knowledge we only have. Nobody else is going to support arguments, the kind of arguments we have. And we have those arguments because we know women, because we support women, and we go with them. Just one thing I want to point out, I don't know how much time I have, but one thing, and this is very important, because for example, with this case, I realized we had women voices in terms of legal representation. Sonia was a lawyer for women, with women. We had women expertise through NGOs supporting the case with third-party intervention. On the other hand, it's very important that our network is considered amicus curiae, considered as an expert from the European Court of Human Rights. It is a recognition that we deserve. And the third thing I noticed is that the Gravia reports was mentioned over and over by all the discussants, not only by Sonia, but the government itself used it. And we need to remember this, because it means we need to be there as NGOs, giving our voices to the Gravia when it comes to visit our country, to put our knowledge and to build the future cases. Because for most of the cases, Gravia report was not available before. It is something new. For the cases reaching the even the normal chamber, those cases didn't have a Gravia report. Now they do, and this will change jurisprudence. I'm positive about that. I just finished mentioning one very important part of our third-party intervention, and it deals with custody rights and victim blaming. Because one important, Dire will make the third-party intervention available, of course, in public, and share it. And one very important thing that is very common, and it was already in the case, was the fact that your client, Sonia, didn't stop visiting rights for the father. So she continued, so she allowed the children to have contact with the father. This is very common and very dangerous, because it's never, nobody consider the risk on the children just to harm the mother. So as an example of victim blaming, the mother was not supposed to stop the contact between among children and the father, because there was no limitation. In Italy, something like that would be like you have to continue visit on the other hand, she's considered not, they say she didn't fear for the children herself, otherwise she would have stopped it. But in Italy, if she says something like that, she would be considered an alienating mother. And then she would be, everything will be considered as instrumental to gain better visiting condition or custody condition. Again, it is shifting to the mother, the attention, and blaming her for something that she couldn't do. This was very important for us, and that's why we pointed out in our third-party intervention. So we had, you will see it, but we had two specific issues, issues that we faced. One was the balance between the right to life and the visit right. That's never considered. And the second one was the victim blaming of focusing on the woman behavior instead of the perpetrator fault. That's all. Thank you very much.
Thank you, Elena. It was an interesting intervention. I'm looking forward to seeing even the link between custody and visitation rights in terms of Article 2 as well. So very much looking forward to that. And also, as you mentioned, you know, despite the fact we talk a lot about the backlash, you did bring out something positive in all of this, and how even us all here, all women, you know, especially our panelists, some amazing women, and also our attendees, how, you know, that women did get together, and when we get together, you know, we are the experts at the end of the day, and we can highlight, you know, bring and perhaps join the forces in order to change the culture that is permeating pretty much everywhere and fight back the backlash. Just a little reminder, if you want to ask questions, you can put your questions in the Q&A or put them up in the chat or raise your hands. I will now move on to our last speaker, Dr. Maria Adriana Kostopoulou. She is a human rights lawyer. She's also a member of Grevio and a member of the consultative board for the European Programme for Human Rights Education for the Legal Professions, HELP, of the Council of Europe. She is the chairperson of the steering committee of the Council of Europe on the Rights of the Child. In her presentation, Maria will talk about the value and impact of third-party interventions, with a focus on the third-party intervention by monitoring bodies, and with the legal arguments used by Grevio in the intervention of the Kurt case. Adriana, floors to you.
Thank you very much, Ara, and I would like to warmly thank WAVE for organizing this webinar and for the kind invitation to participate in it. I'm delighted to be here with great panelists, and Rosa, very happy to see you again, even virtually. This webinar presents a very good opportunity, I think, to discuss various legal arguments that can be used by practitioners, both at national and international level in case of domestic violence. And I would like to highlight that all arguments can and should be used and invoked before national authorities as well, before police officers, prosecutors, and judges who have the primary responsibility of applying the provisions of the Istanbul Convention and, of course, of the European Convention on Human Rights. So my first point is, for legal professionals, is not to wait necessarily to reach an international instance, but already at national level, to invoke and refer to national authorities' obligations under relevant conventions. The more we as legal professionals use and invoke the Istanbul Convention, the more we contribute to the development of a legal culture, I would say, which is gender sensitive and which responsibilizes the authorities in cases of domestic violence and violence against women. So as we heard, the hearing of the court case before the Grand Chamber took place last week. The case is of course still pending, and this is why I will refrain from commenting on its particular circumstances and will not refer to the facts. I will rather focus on the legal arguments used by Grevio in its third-party intervention, which is public. Grevio being, of course, the monitoring body which oversees the implementation of the Istanbul Convention by member states, by member parties. So why did Grevio decide to proceed with a third-party intervention before the European Court of Human Rights? Because there is an added value in third-party interventions. Let's say first that interventions may concern national law matters and issues relating to international law,
I think we might be experiencing some technical issue with Adriana.
Let's give her 1 minute. I think she's gonna unfrozen.
Hello?
Welcome back, Adriana.
Yeah, can you hear me now?
Yes, yes, we can.
Yeah, can you see me as well? Okay, sorry for that, there was a problem with my connection. So I was saying that the court has never considered the provisions of the convention to be the sole framework of reference for the interpretation of the rights and freedoms enshrined therein. To the contrary, the ECtHR must be applied taking into account any relevant rules of international law applicable in the relations between the parties. So in some instances, the third-party interventions have played a part in the development of the court's case law. So in this context, it was Grevio that decided to submit its first observations. The same, as we have heard, did other stakeholders as well. And I would like to highlight that back in 2009, in the famous Grand Chamber case of Opus against Turkey, there was only one third party, while in the court case there were several, and I think this is a very positive note that needs to be highlighted. And a small aside, given that today we are addressing primarily legal professionals, according to the ECtHR, any person concerned who is not the applicant can ask leave to submit written comments. That is, monitoring bodies, NGOs, both national and international, independent experts, research centers, independent national institutions for the protection of human rights, and so on and so forth. With its intervention, Grevio sought to address the issues arising from the court case related to the implementation of the Istanbul Convention. Grevio tried to demonstrate how the standards of the Istanbul Convention can offer guidance on what it means for the authorities to take due account of the particular context of domestic violence and the recurrence of successive episodes of violence within a family. In other words, how can the obligations of the state under Article 2 of the Convention of the ECtHR that protects the right to life be interpreted and applied through the lens of the Istanbul Convention and the obligations stemming from the latter? Due to time constraints, I will refer to some of the points that Grevio made in its third-party intervention, and mainly to the obligation of states to apply engendered understanding when dealing with domestic violence, the obligation to carry out standardized risk assessment, to train professionals that deal with domestic violence, and the issue of barring orders in case of immediate danger. Regarding gendered understanding, when interpreting Article 2 of ECtHR, the court has emphasized that special diligence is required when dealing with domestic violence cases. It has considered that the specific nature of domestic violence must be taken into account. But what does this mean in practice? Guidance, I think, can be given by the Istanbul Convention. As we all know, in line with Article 42, paragraph 2, 49, paragraph 2 of the Istanbul Convention, the competent national authorities entrusted with the task of preventing and prosecuting the offences and protecting the victims shall take into account the specific nature and dynamics of domestic violence, which is a manifestation of male violence against women, based on the notion of the inferiority of women. So in order for national authorities to meet the obligations stemming from Article 2 of ECtHR, they need not only to have, but to showcase a gendered understanding of domestic violence. Domestic violence, which, as we all know, is by its nature cyclical, recurring in time, and with a tendency to escalate. This is why victims may not immediately report the violence, or may withdraw the complaints, or even forgive their violent partner. Research indicates that women typically seek protection orders after serious level of victimization and after abuse over a significant length of time. So against this background, my first general question to be addressed is the following. Can we really say that statutory agencies have offered adequate responses to women victims under ECtHR if they haven't demonstrated any gender understanding of domestic violence? And with this question, I will move to the second point about risk assessment. Article 51 of the Istanbul Convention provides further guidance on what positive obligation to protect a woman victim's life means. All relevant authorities, including but not limited to the police, must effectively assess and devise a plan to manage the safety risks that a particular victim faces on a case-by-case basis, according to a standardized procedure, as was mentioned, and in cooperation and coordination with each other. Article 51 requires the police to carry out a risk assessment for the victims as of receipt of the complaint, using standardized tools with pre-established questions that the competent authorities must systematically ask and answer. This obligation to effectively assess the risk inherent to an individual domestic violence situation falls squarely on the statutory agencies, as Rosa mentioned as well. It is the obligation of national authorities to collect and to assess all relevant information. The competent authorities should not rely on the victim's own assessment of the risk, which, due to the dynamics of domestic violence, may not be objective. The science which deals with the dynamics of power and control typical to domestic violence is nowadays, I would say, super sufficiently developed, and there is a large variety of tools already proved to be efficient in assessing risks and in identifying safety measures. I think we can no longer ignore the existing tools we have in order to respond effectively to domestic violence. We can no longer pretend that this is an unexplored area and that the choice of responses can be made without standardized assessments. So my second question is, can we really say that national authorities have fulfilled their obligations under Article 2 of ECtHR if they have not in place specific protocols, risk assessment tools, if they do not consider domestic violence as a continuum of violence, but rather as an isolated episode? Have they fulfilled their obligations if they have heavily relied upon victims' own assessment of the situation? And I'm coming now to my third point. Article 15 of the Istanbul Convention stresses the importance of providing or strengthening training for professionals dealing with victims or perpetrators of domestic violence, training on prevention, detection of such violence, on equality between women and men, on the needs and the rights of victims, and on how to prevent secondary victimization, and how this obligation can match with the ECtHR and the positive obligations under Article 2 of it. Back in 2004, in the cases of Makaragis versus Greece, which concerned the excessive use of force by police officers, the Grand Chamber insisted on the obligation of states to afford to law enforcement officials clear guidelines and criteria governing the use of force. Likewise, in the area of domestic violence, the system in place should afford law enforcement officials clear guidelines and criteria governing their action or intervention. According to the explanatory report of the Istanbul Convention, any training should be supported and reinforced by clear protocols that set the standards staff are expected to follow in their respective fields. Training of police, prosecutors, and judges on domestic violence is essential in order to evaluate the risk of reoffending and take the necessary measures of protection. And with this, I'm coming to my last point regarding barring orders. Article 52 of the Istanbul Convention establishes the obligation, in cases of immediate danger, of equipping the competent authorities with the power to order a perpetrator of domestic violence to leave the residence of the victim or the person at risk and to bar him from entering the residence or contacting the victim or person at risk. The protective scope of the barring order extends to victims and to all individuals at risk who should be protected, regardless of their relationship with the perpetrator. In this case, the protection should be given to the victim's children without any discrimination, for instance, on grounds of sex or age. Thus, any regulation that is limited only to banning the perpetrator from the residence of the victim, but allows him to contact the victim in other places, would fall short of fulfilling the obligations under the Istanbul Convention. And the same applies with regard to regulations that protect only the victim and not other persons at risk, including victims' children, or regulations that extend the protection to the victim's children under specific conditions, such as age limitations. As we all know, previous reports have commented several times on shortcomings in protecting child victims and witnesses from their abusive parents through the issues and implementation of emergency barring orders. Such shortcomings include, very briefly, just a few examples, instances in which children are not always systematically included in protective measures, or when they are included, but due to the lack of multi-agency approach, they don't receive efficient protection. In the light of the above, it is of paramount importance that national authorities, including judicial authorities, evaluate the existence of a danger for the child at all stages and seek the adoption of protective measures, such as barring orders, even if these measures were not taken in the beginning of the proceedings. And my question here is, shouldn't all the above considerations be taken into account when applying Article 2 of the European Convention on Human Rights? So to conclude, I tried to show how the obligations stemming from the Istanbul Convention are closely interrelated with those arising from Article 2 of the European Convention on Human Rights. To our view, Istanbul Convention provides guidance and concretizes what should be expected by national authorities in order for them to fulfill their obligations stemming from international conventions. Adequate responses to women victims require inter alia gender understanding when dealing with domestic violence, a standardized risk assessment, training of professionals that come into contact with victims on the particular dynamics of domestic violence, and a protective scope of the barring orders that extends to victims and to all persons and individuals at risk. Thank you very much.
Thank you so much, Adriana. And thank you again for highlighting the importance of having third-party interventions in such cases, and as well as reinforcing that we need to take all that is happening within the European Court framework and bring it down to our national level in terms of also accountability and positive state obligations, not only with regards to prevention of violence against women, but also in accountability. Okay, so that was the end of our panel's presentation. Now we will move on to question time. Yes, as I mentioned, yeah, please do write your questions in the Q&A or in the chat box, or raise your hands, and we will try to ensure that your questions get answered. We do have, however, 2 questions already. First question is for you, Sonia. Since the perpetrator killed himself, did you first initiate proceedings in Austria to determine the failure of the professionals in charge of protection, or did you go directly to the European Court of Human Rights?
Yes, in order to go to the European Court of Human Rights, you have to try it first in Austria. So we did that. We did not succeed in Austria. Let me just take out something. So first of all, our client filed for the there is a law in Austria called the Liability Act, and therefore you can ask for damages in case the Austrian authorities failed to fulfill their obligation. But in this case, the courts in Austria argued nearly the same like the authority, the Austrian government in the proceeding before the European Court of Human Rights. They also said how should the police officers and how should the public prosecutor should have known that there is a real risk. He had threatened all the time before on a daily basis, so he never did it. Where do we know that? Where should have we known that he is now a real threat to his family? They also use the argument, like the European Court of Human Rights, it's nearly the same. They also use the argument that the violence was always at home and not in public. So bearing order, covering the home was enough. He could not come home and he never did anything in public. So it was nearly the same argumentation. And they also said they didn't know that he had a weapon. And we argued, you can also kill a child with a knife. Most of the murders, according to a screening group on murders and attempted murders, which was initiated in 2019, most of the murders are in 2020. Most of the murders in Austria in partnerships is done by knives. And he was also the owner of a kebab stand. So he had access to other weapons than a gun, and he could also do it with his bare hands. He could have choked his son. So this was not an argument for us. Also, we said the police failed to ask our client if her husband has access to a gun, because if she would have been asked, and she was asked by me in our Austrian court case, does your husband have access to guns? And she said in this process, and she would have also told the police, he always said, it is so easy to get a gun for me, just one call is enough. So this is also an error the police made. They don't ask systematically questions concerning the case. It is always, oh, what does the victim tell me? Like by herself. She has to be very active. She has to be, you know, prepared and listing all incidents. And they don't really go into the deep and ask themselves, but it's their job to ask and to find out what happened. And they also don't have a tool, so they miss some questions. They don't ask if there were weapons involved. And yeah, we had a process in Austria, but we went until the highest court, and they all said no. The Austrian authorities could have not known. Thank you.
Thank you, Sonia. So we move on to our next question. I think this one is for you, Adriana. Is it the first time that Grevio intervened in this form in a European ECtHR DV case? Are there any institutional regular exchanges in respect of respective roles, of course, with the ECtHR and the Violence Against Women group? Is there any space for this eventually for future, in terms of having some sort of experts exchanging training of ECtHR judges by Grevio experts?
Thank you very much, first of all, for this question. Yes, indeed, this was the first third-party intervention and written submissions by Grevio. On the 21st of January this year, we submitted it. And we have already established a working group that will be dealing with this issue, as we want to reinforce synergies with the court to bridge and also to provide guidance as we can as a monitoring body of the Council of Europe. And given that Grevio has the added value of on-site visits, we visit countries, as you all know, we exchange with NGOs, with the civil society, with academia, with national authorities, and this expertise and knowledge could be certainly very useful for the court as well. With regards to the exchange, last year, I think it was for the first time, if I'm not wrong, the then president of the European Court of Human Rights visited, had an official exchange with Grevio members with a delegation of ECtHR judges. And I hope that this dialogue between Grevio as a monitoring body and the European Court of Human Rights will continue under the current president of the court as well, because as I said, we are a part of a system. The court is a part of the same system of the Council of Europe. Now, with regard to third-party intervention, and that concerns not only Grevio, but all of us, there are also some technical, I would say, challenges given that the request for leave for third-party intervention has to be submitted within a specific timeline of 12 weeks after the communication of one case to the responded government. Regarding cases that arrive to Grand Chamber, this is more obvious because it goes all over the news. So we are informed in real time about the referral request, and all of us know when we should react. On the contrary, with regard to chamber cases, someone has to shared and see when cases that are to the interest and that concern domestic violence and violence against women are communicated to the respondent government so as to react within the time limit of 12 weeks. And this is a challenge. And my last point regarding training, I will change a bit hat and will refer to help courses on access of women to justice and on violence against responses on violence against women, help courses of the Council of Europe that could be very useful for legal professionals, judges, prosecutors, and lawyers. Thank you.
Thank you, Adriana. Move on to the next question, and it's back to you, Sonia. So what was your biggest challenge during the case, and where did you feel there was most resistance?
That's a difficult question because before the third party interveners intervened, we felt pretty much alone on our side, because the chamber decision, the first decision, was so in favor of the Austrian authorities, and they like copied their argumentation. And all the things I told you today about argumentations, this was not new reasoning which we invented like before the Grand Chamber. We said that in the very beginning of the first Austrian court cases, and we had a line up until last week in front of the Grand Chamber, and they seemed to ignore everything we said, and it was so frustrating, because we told them that the lack of knowledge is a problem and caused problems, and we also explained to them how important it is to make a risk assessment, and they seem to really ignore every argument. And I was like, do they even read what we say? But then and we were fine, like, I don't want to tell too much because this is going to be public, but we had, after we received this negative decision of the first chamber, we sat together with Rosa, and I was telling her about the case, and she was like, you have to do something. We cannot leave that like that. And I was like, yeah, we could, like, technically, theoretically, there would be the possibility to ask for a referral to the Grand Chamber, but wow, I never did that, and I don't know anybody who did that before, and what shall we say? I mean, there's a lot to say, but will this work out? I know that less than 1% of all these requests go and are successful. And then I didn't read the judgment because I was so angry about the outcome. Then I read it, and then I was even more angry because I was angry. I will leave it like this. And then I was really motivated to do it again. And we had so much support of the Verein Frauenrechtsschutz. It's an NGO who financially supports women so that they have legal access to do these kind of cases. We heard that today, that it's so difficult for women to get access to their rights, and they supported from the very beginning of the Austrian court case until now the Grand Chamber, because it is also it's not about our costs, it's about also, if you lose a case, you have to pay the government's costs, their lawyers, and that's what Ms. Kurt had to do after losing the first episode of processes in Austria. So they also supported us, and together we were like, okay, let's do that. And when the third party interveners wrote their submissions, I didn't feel lonely anymore. They were so inspiring, and they were so in our favor. And I was like, yeah, now the authorities have to listen to us. It's a very, very public and a very big thing now. And you can also see how many people they invited to speak for them. It were 8 agents, like the highest agents of the Austrian ministries from 4 different ministries. And they really tried everything. So they don't want to lose this thing, but we also don't want to lose this thing. So thank you for the support of the third party interveners.
Thank you, Sonia. We now go on to our final question, which is related to child visitation. Does he have any official statements? I'm assuming that this is Mr. Kurt's statement regarding his visitations. And how are the children's services, those which decide regarding child custody, involved in the process? I'm assuming, Sonia, this question also goes to you. Due to time constraints, if we could keep it a bit brief.
Or does Rosa want to answer to it? Because she also mentioned it in the, I don't know.
Sure, Rosa, by all means.
No, Sonia, go ahead, please.
Okay, then please, could you once more read out the question to me, very briefly.
It's related to child visitation. The question is, were there any official statements regarding the visitation right, and how the children's services, those which decide with regarding to child custody, involved in the process, if they were involved in the process, of course?
Okay, there was no visitation right process. The Miss Kurt was married to her partner, to her husband. She went to file a divorce file. She went to report him to the police, and there were just 3 days, and then her son was shot. So there was no time to ask for a visitation regulation by the state. But usually in other cases, I can tell you that it is very, very difficult to make it clear to the judges in Austria that a father shall not see his children because of violence. If it's violence between man and woman, the parents, then it doesn't count at all. It seems to not count at all for the Austrian judges because that does not affect the children. So if children are witnesses of violence against their mother, this is not a reason for the Austrian judges to limit the contact between father and children, even though they are, it's difficult for them and they're also traumatized maybe. If there is violence against the children, it's a difficult situation, it's another situation, but also then you have to really argue a lot why the father shall not see the children at all. This is the last ultima ratio. First of all, they always try to convince the mother, if she doesn't, or rule also against her wish, that the children shall see the father in a Besuchscafé, which is a visitation cafe, a professional cafe, like a playground, indoor most of the time, where social workers and psychologists accompany the father and the children and watch it. It's a supervised visit. And that is the minimum that a father gets. The father lobbies are very, very strong in Austria, and since 2013, they got a lot of rights. And to the child's welfare, to say something to that, the bearing order and the legal situation was changed also after this incident. It was not only also covering schools, but now the bearing order has to be sent to the Jugendamt, the child welfare, and they have the legal possibility, and I think they're also obliged to do that. If the mother does not file for a restraining order, then the Jugendamt can do that instead. They have to do that if there is danger. In fact, just to also inform you about everything, the mother had already made an appointment with her social worker from the protection center for Friday to file for a restraining order, but unfortunately it was too late because her son was shot a few hours before that in the morning.
Okay, we've got another question. Sonia, you made reference to some organizations supporting women's access to justice. Could you please provide the names again? Or maybe Rosa, yes, as well.
Rosa, or I just tell you once more, it's Verein Frauenrechtsschutz. They provide financial help, and they're also very, they have a lot of knowledge about domestic violence, and they're really great, but of course they cannot finance everything. They have limited money. And then of course there are the intervention centers, the protection centers. They are there to help women, to protect them, to file for restraining orders, but this is a question for Rosa maybe. Shall
we unmute her from?
Is Rosa gonna answer?
I think she's having problems.
Okay, I'm trying. Just very briefly, I think you said everything important. It's a women's NGO. It's very active lawyers and other women collecting money, applying for money to have these cases, to get the court cases to the higher instances. This is what Elena was also mentioning. No, because you need the money. Because as Sonia said, if you have to pay if you lose the case to the other party. So, and that's great. They only support Austrian cases, I think, so far, because it's also not a big organization, but it's good to have that in every country to build it up. They could in every country to as a tool also to be able to go to higher instances. And just as a last comment, because I think we have to finish our great webinar. I think it was very good to exchange that, and I think it would be good if we can continue. We have to make this case even more known. I hope the WAVE office will continue that, to have maybe more webinars to make sure that more people know about this. It also will take a while before the court, maybe Sonia can say that, will issue the verdict. So I think we should also use this time, this month, to inform more people in Europe and maybe internationally about this case and the third party statements. And I think we should really use the work we have been doing. We have been writing, we have been doing more in going public. I mean, I was hesitant first that this would be public already now, because I thought it was for WAVE members and we shouldn't, but we can, as a next step, or even we can see if we want to make it public now. I think it would be good to raise awareness about these core problems, because as you have said, the same arguments everywhere in this world, apparently, without anybody having to train them to use these arguments. That's the miracle to me in patriarchy. Everybody knows the arguments without having to learn them, but to unlearn them needs a lot of effort. So I really hope we can continue this awareness raising and include other experts. And I wanted to thank all the WAVE colleagues for taking this initiative.
Thank you, Rosa. And I know we have some other pending questions, however, time is up. It was a fantastic webinar. I think one of the best, especially, with legal minds, and very fascinating, very interesting. I really want to thank you very much for all our panelists and your fantastic contributions. And of course, as Rosa said, to the WAVE office to have taken the initiative. And I very much look forward to hosting, attending similar webinars. Have a good afternoon to everybody.